Today we're looking at a pretty high-stakes collision.
A real balancing act.
Exactly. That's what our source, HTW Law, calls it. It's this tension between freedom of expression and, the right to protect your professional reputation.
And we should be really clear here. This isn't about someone spreading rumors at the water cooler.
No, not at all. Legally speaking, the threshold is, well, it's incredibly high.
It is. We're talking about statements made intentionally, publicly, that cause actual measurable damage.
And that's an important distinction because this is civil litigation. It's not criminal law.
Right. So the focus isn't punishment. It's all about restitution. The source calls it compensation for an unfair action.
The goal is just to be made whole, to get your life and your reputation back to where they were.
But what's fascinating is how easily this can happen in a workplace context, especially around a termination.
Oh, absolutely. The source points to what they call the bad reference scenario.
A classic example.
Yeah, so you have an employee who's terminated without cause. That's normal. But then the employer, they don't just refuse to give a reference letter.
That would be one thing.
Right. The legal problem starts when that employer goes out and starts trashing the employee's reputation. That's the word the source uses.
And that word trashing implies intent, which is key.
Well,
But there's another scenario in the notes that I think is even more, insidious.
the weaponization of professional bodies.
Yes. That one is genuinely terrifying.
It really is, because it's not about one job anymore. It's an attack on your very license to practice.
You're talking about someone filing a bogus disciplinary proceeding
Right.
with a medical board or a law society.
And the whole point is just to cause harm, to inflict emotional distress.
Exactly. It's not a real complaint about competence. It's using the system to ruin someone.
Which brings us to this massive contradiction in the source material. I really want to drill down on this.
The make it or break it nuance.
Yes. So the law technically says you don't need medical evidence to prove you've suffered emotional distress.
In theory, the damage to your reputation is, by itself, enough.
That's the theory. But what happens in practice?
Well, HTW law is very clear. They say time after time that medical evidence becomes the single decisive factor for the court.
So if you can't show medical records, proof of the physiological toll it took on you.
The courts are just incredibly hesitant to rule in your favor. It's a huge hurdle.
So strictly speaking, it's not a legal requirement.
But practically speaking, it's almost a prerequisite to win.
You basically have to medicalize your reputation damage for a judge to take it seriously.
It creates this huge gap between the statute and the reality of litigation.
And that really connects to the other big warning in these notes, that these suits are highly technical.
Extremely complicated. This is not something you navigate on your own.
Especially with the timeline, that idea of being statutory barred.
It's critical. The limitation periods for defamation can be much, much shorter than for other claims.
So if you wait too long, if you hope the rumors just blow over,
you could find yourself completely barred from taking any legal action at all. The clock starts ticking right away.
So if we pull all this together, the big takeaway for professionals listening is that business goodwill isn't just a vague concept.
No, it's a tangible asset. It's currency, especially if your livelihood depends on your standing in the community.
You have to be ready to protect it.
With the same rigor you'd protect your bank account. And civil litigation is the tool you use to do that.
It's the tool, but as we just saw with the medical evidence issue, it's an imperfect one.
Very imperfect.
Which leaves us with a really difficult final thought for you to chew on. If the law says medical proof of distress isn't required, but the courts almost always demand it to rule in your favor, does our legal system actually prioritize the technicality of the injury over the reality of the reputation damage?
That's the disconnect every single plaintiff in these cases has to navigate.
Thanks for diving in with us.